unique blend of rigidity and flexibility. It has been the nature of the amending process itself in federations which had led political scientists to classify federal constitution as rigid. A rigid constitution is one which requires a special method of amendment of any of its provisions, while in flexible constitution any of its provisions can be amended by ordinary legislative process. A written constitution is generally said to be rigid. The Indian constitution, though written, is sufficiently flexible. It is only a few provisions of the Constitution that require the consent of half of the state legislatures. The rest of the provisions can be amended by a special majority of Parliament. The fact that the Indian Constitution has been amended more than 100 times after its commencement disapproves the view taken by Sir Ivor Jennings, who had characterized our Constitution as rigid for the following reasons: that the process of amendment is complicated and difficult, that matters which should have been left to ordinary legislation having been incorporated into the Constitution, no change in these matters is possible without undergoing the process of amendment. Fundamental rights. The incorporation of a formal declaration of fundamental rights in Part 3 of the Constitution is deemed to be a distinguishing feature of a democratic state. These rights are prohibitions against the state. The state cannot make a law which takes away or abuses any of the rights of the citizens granted in the Part 3 of the Constitution. If it passes such a law, it may be declared unconstitutional by the courts, but mere declaration of certain fundamental rights will be of no use if there is no machinery for their enforcement. Our Constitution has therefore conferred on the Supreme Court the power of grant most effective remedies in the nature of writs habeas corpus, mandamus, prohibition quo warranto, and certiorari whenever these rights are violated. It must, however, be clearly understood that fundamental rights are not absolute rights. They are subject to certain restrictions. Thus, our Constitution tries to strike a balance between the individual liberty and the social interest. The idea of incorporating a Bill of Rights has been taken from the Constitution of the United States. But the guarantee of individual rights in our Constitution has been very carefully balanced with the need for security of the state itself. Directive principles of a state policy. The directive principles of a state policy contained in Part 4 of the Constitution set out the aims and objectives to be taken up by the state in the governance of the country. Unlike the fundamental rights, these rights are not justiciable. If the state is unable to implement any provisions of Part 4, no action can be brought against the state in a law court for this want of enforceability, there has been much criticism, but the criticism is not justified, though by their very nature they are not justiciable in the court of law. Yet the state authorities have to answer for them to the electorate at the time of election. The idea of a welfare state envisaged in our constitution can only be achieved if the states endeavor to implement them with a high sense of moral duty.